Hey everyone! So I haven't uploaded in a few months because I've been so busy and I've been doing a lot of things, but among those things is still law school. So this semester I took up civil procedure, which in one of our discussions we touched upon the expedited rules or administrative matter number 0887 SC, which was recently effective. So the Supreme Court recently issued the rules on expedited procedures in the first level courts, or in short, the expedited rules. This took effect last April 11, 2022, so lately lang to, and these rules will significantly affect the manner in which the cases are handled, prosecuted, defended, and resolved in the first level courts. So the summary of this discussion is based on an article written by my professor, attorney Tranquil Salvador. So let's begin. So before anything else, this discussion will only include the civil aspect of the expedited rules, and I will only um, discuss the first part of the discussion because those were only what we discussed in our summary for the class. So sorry, I've been it's been so long since I did this. So we go to the first level courts. They are the metropolitan trial courts, the municipal trial courts in cities, and municipal circuit trial courts. So the issuance of the expedited rules will recalibrate, reconcile, and harmonize the rule on summary procedure, the rule on small claims, with the Republic Act 11576. So we go first to RA 11576. This expanded the jurisdictional amounts in the first level courts to those amounts not exceeding 2 million pesos for claims in civil cases, and the second one is for those not exceeding the assessed value of 400,000 for actions involving the title to or possession of real property or interest therein. So the expedited rules highlight the move of the judiciary to further accelerate the disposition of the cases in first level courts. The implementation of this renewed policy will be possible with the help of the proactive judges who have they have a strong support staff and who will hear and resolve cases in a timely manner. So the expedited rules on summary procedure in Rule 1A, Sections 1 and 2 will be discussed in the next slide. So we see on our screen Rule 1A, Section 1. So Rule 1 is applicability, and we see on our screen, as I said, Rule 1A, Section 1, subsections A to F, which is for summary procedure cases. So the expedited rules on summary procedure increase the maximum value of civil cases and complaints for damages that first level courts can resolve up to 2 million pesos. So we see this under Rule 1A, Section 1, subsections B and C. This development will accelerate and resolve issues on money claims and cases on damages in that level. So examples of these are recovery of sums of money or personal properties or complaints for damages due to negligence. So, with the expedited rules on summary procedure, more civil cases will be resolved by the first level courts, since after the preliminary conference, mediation, and judicial dispute resolution, especially when these proceedings will still result in an unresolved case, the parties will be ordered to submit their position papers. If it is still necessary, we take note of that, and without need of a trial, then soon thereafter, the court can proceed to render judgment. See, it's really a much easier and expedited procedure. So wala na yung hassle of going through trial. And as I said, kaya nga expedited siya, may judgment na yung court for those cases that I mentioned. So excluded from the expedited rules on summary procedure are probate proceedings, admiralty and maritime actions, and small claim cases falling under the rules on small claims, which are incorporated in the expedited rules. We'll discuss small claims in a bit. So, however, forcible entry and unlawful detainer cases remain to be covered by summary procedure. So, we see this under Rule 1A, Section 1, subsections A and B. So also included in the expedited rules and summary procedure are the enforcement of barangay settlement agreements and arbitration awards where the money claim exceeds 1 million pesos. So revival also is revival of any first level court judgment if not enforced within 5 years from the finality. And lastly, civil aspect of a violation of the bouncing checks law. So this is BP 22 if no criminal action was instituted. So to reiterate, this is under Rule 1 A, section 1, subsections D, E, and F. We see that on our screen. So next, so we go to, we're still in Rule 1A, but now we go to Section 2, which present expedited rules on small claims. So here, the rule adjusted the amount for small claim cases in the first level courts to not exceed 1 million pesos exclusive of interest and costs. So a small claim is an action that is purely civil in nature where the claim or relief raised by the plaintiff is solely for the payment or reimbursement of a sum of money. So the small claim may be for money owed under, for example, contracts of lease. This is subsection A. Then contracts of loan and other credit accommodations, contract of services, contracts of sale of personal property, and the enforcement of barangay settlement agreements and arbitration awards where the money claim does not exceed 1 million pesos. So if it exceeds the said amount, 1 million pesos, then the case will fall under summary procedure. So the intention of the Supreme Court in providing the expedited rules on small claims is to provide a simplified and inexpensive procedure for the disposition of small claims cases. Because you're just going to claim a small amount of money, which does not, well, it's not small, but if it does not exceed 1 million pesos, parang ayaw na nilang patagalin pa. So they want this to be expedited, to that there be judgment already. So this type of action does not require the representation of a lawyer, and no formal pleading is required except for the settlement of claim, which is available in court. So next, we go to the procedural differences. So, kasi the procedural difference of Rule 1A, Section 1 and 2. So, summary procedure and small claims. While the expedited rules on summary procedure and small claims are intended to hasten proceedings in the first level courts, they have procedural differences. So, we're going to discuss here first their difference in the period to file an answer. Second, the effect of failure to file an answer or response. Third, the proceedings after filing an answer or response. Fourth, the applicability of mediation and judicial dispute resolution. And lastly, what are the remedies after the judgment? So for the period to file an answer or response, in summary procedure, the period to file an answer is within 30 days from the receipt of summons. This is under Rule 3. In this Rule 3A, Section 6, while the period to file an answer, a response rather, in small claims is within a non-extendable period of 10 days from the receipt of the summons. This is in Rule 4, Section 13. So, second, we go to the effect of failure to file an answer or response. So, in summary procedure, the court, on its own initiative or upon manifestation of the plaintiff that the period for filing an answer has lapsed, shall already render a judgment. So, this is under Rule 3A, Section 9. And on the other hand, in small claims, the failure to file a response coupled with the failure to file with the failure to appear on the date set for the hearing will push the court to render a judgment within 24 hours from the termination of the hearing. So, ang bilis talaga. Imagine, just one day. So, third, we go to the proceedings after answer or response. So, in summary procedure, the clerk of court, within 5 days after the filing of the last responsive pleading, shall issue a notice of preliminary conference, setting such conference within 30 days from the filing of the last responsive pleading. This is found in Rule 3A, Section 10. While, on the other hand, in small claims, the court shall hear the case on the date set for the hearing and render a judgment within 24 hours from its termination. So we go to the applicability of mediation and judicial dispute resolution. So in summary procedure, we have that the court shall issue a preliminary conference order referring to the parties to the mediation and judicial dispute resolution. This is Rule 3A, Section 13, while there is no such referral required in small claims because the parties may enter into a compromise at any stage of the proceedings. So this was said in Rule 4, Section 27. And lastly, we have remedy after the judgment. So in summary procedure, the remedy in case of an adverse judgment is what you do is to appeal. A motion for reconsideration of judgment is a prohibited pleading. So this is found under Rule 3. Section C, and Rule 2, Section 2. So the remedy naman in small claims is a petition for certiorari, since the decision or judgment of the court shall be final, executory, and unappealable. Imagine it was a decision made in 24 hours, but it's already final, executory, and unappealable. So what you do is you file for a petition for certiorari. So for my professor, Attorney Trangkil, the most important innovation introduced by the Supreme Court is the power given to the judges of the first level courts to dismiss the case of their on their own initiative. So undoubtedly, this will spur the resolution and disposition of more cases even before the answer or response is filed by the defendants. The grounds for dismiss so here we go for the last one, which is grounds for dismissal, which includes the lack of subject matter jurisdiction, improper venue, lack of legal capacity to sue, litis pendentia, res judicata, prescription, failure to state a cause of action, non-submission of the certification against forum shopping, and lack of compliance with the condition precedent that this can be found in Rule 3A, Section 4, and Rule 4, Section 9. So these grounds for motu proprio dismissal by the court are made available to proceedings concerning either summary procedure or small claims, except that there are two additional grounds for dismissal in the latter set of rules in the small claims. So yung grounds na to is yung absence of jurisdiction over the person of the defendant and failure to submit the required affidavits, which is found under Rule 4, Section 9. So ang daming inintroduce talaga nitong expedited rules natin. So the goal of the Supreme Court is to simplify and expedite the proceedings in the first level courts. This reflects its genuine intention to improve the administration of justice and advancement of the constitutional right of persons to a speedy disposition of cases. So as my professor said, this expedited rules is a big leap towards making the courts truly accessible to every litigant in this country. So this ends our short discussion. I hope you learned something from it, and stay tuned for my next ones. Thank you.